Yeah. When you get older, it's I had a problem with my phone last week. I didn't realize today's was really my counting backward. Great at reverse. And I got everybody thinking it's with yeah. Well, I called in at 6 top of the J's. I said, hey, do I have I checked in and said, and then he said, oh, no. So I was leaving. Yeah.
Waiting on court reporter, I don't know where she went. Oh, there she is, all right.
Yeah.
The matter of state of Ohio versus Michael Boyajian,
Correct, voice.
case number B 2402984. Mr. Boyajian is represented by Mr. Frank Roney, Mr. Frank Brown, the state of Ohio. This matter is on for trial today. Mr. Roney, I see you filed a motion to have the defendant evaluated for competency. And, did you work with Ms. Howard on a date already?
No, Judge, I have not, we don't have a date set for that. I did just file it.
Okay. Okay. Yeah, all right, so, we'll go ahead and continue this to September 23rd. Can you do that?
One second, Judge, check the calendar. We'll make it work.
All right, continue for competency, 9:23, 9 a.m. Do you waive your client's presence for today?
Yes, Judge, wait a second.
Okay, and the motion obviously moves time. Anything from the state?
Judge, do we want to just keep the following trial and jury trial date that we currently have?
We're gonna keep it right now and see if he was left.
Yeah.
It looks like it probably will be vacated, but we'll see what the competency evaluation reveals. Okay? All right, thank you. Have a good day.
There we go. Next time.
All right. Who we got next?
So we've got Mr. Howard, who is currently locked up, I believe.
All right, do you want to write down, Council Mikey?
Judge, I might like to, if I could, report to the commission, take a couple of days to talk to him. This came on my calendar late last week, and I might just take a day or two to talk to him, whatever you want, later this week, maybe. That's all right.
So are you saying you haven't had a chance to talk with him yet?
I haven't had a chance to talk to him.
Okay.
I'm trying to remember this case, honestly. I'm blanking for some reason. I may have just found it. If I had a day or two, even if I just do tomorrow, that's fine, whatever.
Well, since he's locked up, I'm sure he's going to appreciate you getting to him as soon as possible.
I could do tomorrow, Judge. if that's
Well, I don't know that tomorrow, I'm going to be in a trial too, so, civil trial. So, let me see.
So if you're still in trial, so I have time.
Can we see what the rest of the week looks like? Wednesday,
There's 9 cases all in. Thursday, there's 3.
oh, I see.
Thursday would be better, Judge. I could have something to do.
It's a Zoom day,
Pardon me?
it's a Zoom day on Thursday.
It's a Zoom day. I don't mind doing Zoom. I mean, I could, however you want to do it. If he's locked up, is this still Zoom?
Yes, they still do that. All right, we'll do it, we'll continue it for Thursday, the 22nd. 22 at 9 a.m. So Mr. Winky, it's Zoom, and you'll need to appear via Zoom. We'll make arrangements for the jail to have them on. They'll be on at 9, so please try to be on at 9, because I don't want to keep the jail late.
Yes, Judge.
All right?
Is
This
it
is
okay
your
if I come in?
continuance.
But is it okay if I come in still? Even-
No,
I just wanted to-
Door will be locked, it will be by Zoom.
Okay, thank you.
All right, Mr. Brown, this will be by Zoom on Thursday, okay? At the request of the defense.
Do you want a copy of the email? Yes.
All right, who else do we have? Mr. Okay. Mr. Rubenstein. Good morning, this is the matter of State of Ohio versus Anson Ross, case number B 2401631. Mr. Scott Rubenstein for Mr. Ross, Mr. Brandon Brown for the State of Ohio. This matter is on today for a pretrial. And, Mr. Rubenstein, we have some parameters around this case. We had a final pretrial conference set September 19th, and a jury trial date set September 30th. Do you have discovery yet?
Yes, sir.
All right, do you know how you want to proceed? Do you want to keep this matter on just for a month from now for the final pretrial, or what would you like to
Judge, we're good with the current scheduling order.
do? Okay,
I appreciate that.
all right, is your client here today?
He's not, Your Honor. I was out of town last week when this was originally scheduled. It got put on this morning's docket, and I appreciate the combination. I did not notify him, so I apologize if that was contrary to the court's expectation.
So you waived his presence for today?
With your permission, yes, Judge.
All right, so anything from the state?
Nothing, Judge.
All right, well, we'll continue this as already scheduled for the final pretrial conference, August 19th.
Thank you very much.
Thank you.
Do you want to call? Okay, it's not Jeff, I can't.
These are the matters of State of Ohio versus, Jeffrey Campbell, case numbers D 2403360 and D 2402781. Mr. Campbell is present in the courtroom with his attorney, Mr. Arsene Winston, and Mr. Brandon Brown from the state of Ohio. Ms. Winston, we have two cases here. The older of the two already has parameters set around it. We have a jury trial date set September 23rd, and a final pretrial conference date set September 12th. But he has a new case, and we need to set dates on that.
Yes, Your Honor. Regarding the older case, I believe that I have everything discovery-wise. Regarding the new case, I've not received anything yet. So I guess at this point, I agree that we just need to kind of set some trial dates at least for that one.
All right. Mr. Brown, what about discovery?
Judge, I can get paper out to the defense counsel today. I don't see anything in terms of any electronic discovery such as video in this case. I don't know. I don't think there's anything sort of like surveillance like that, but I think that there was quite also the statement that was taken from the defendant in regards to this. But I don't have anything right now. Sharon goes to the police department, so usually they're pretty good.
Okay. All right. So, let's see.
And just for the record, it is my understanding that Sharonville is a police agency that does have body camera.
Okay. All right. Well, it looks like a scheduling order was issued for Mr. Campbell's older case, and he was still in custody. So the dates were advanced, but I see that he's out on bond. We have a little bit more time.
Yes, Your
Would you
Honor.
like to vacate those earlier dates? Are you trying to resolve these together? We don't have to. We can keep them on two separate tracks if you want to, and then perhaps later put them together.
Your Honor, Mr. Campbell would like to keep them all together, so we're about to push it out.
All right. So I'm gonna issue on the scheduling order. My bailiff is out today, so I'm just here to issue this pretty quickly. So what I'm gonna do is initial discovery on the new case I'm gonna set for today. Mr. Brown, you said you can get some stuff to her. And then let's set the trial date. The last trial date of the year is December 9th. Do you need that much time? You want to take that date or?
Yeah, I was gonna say, Your Honor, if we could do November, if the court's available. Mr. Campbell said that he's fine with December 9th, Your Honor, that's easier, just to resolve everything.
All right, if you decide to resolve it sooner, we can advance it.
If you
But- But to set it for the trial, we'll set it for December 9th. We'll put both of them on the same day. 2024 at 9, at 10 o'clock. And then the final pretrial conference will be November 21st. At 9. All right?
That is good for us, Madam Mayor.
All right, and so we'll move both cases to the same schedule now, all right? Now, in order to keep these on track, and to make sure that, you have discovery, and you're meeting your clients, know what you want to do, and inform the court, let's set a date at about, early October, just to make sure that you have discovery, and you decide, where, how you want to resolve it in advance. If not, that's okay too, but it'll be a check-in, okay? So let's, look at. Let's look at October 10th at 9. Does that work for you?
Yes, it does, Your Honor.
Okay, great. So we'll do a pre-trial, October 10th at 9 a.m. Mr. Campbell, please keep in contact with your lawyer, and then she'll let you know, when you need to be here and, what's happening, okay? All right, so I'm gonna set the date for October 10th at 9 a.m. Anything else, counsel?
No, Your Honor.
Anything to say?
Nothing, Judge.
All right, time waiting?
Yes, Your Honor.
Thank you.
Thanks, Your Honor.
Thank you. Is it the right plan? When I say through the house, let's make sure.
I can call it later.
I think that's what's over.
I'll call back.
Can you confirm?
Yeah.
Thank you.
So we have a here for Bruce Smith or Thomas Prairie. Okay. That's still time on two. Yeah. Wasn't it? So I can find you, so I just want to do it here.
Okay.
Yeah.
That's what we always put there, right? All right, this is the night. This is the night.
Thank you. All right. Anybody else ready? Ms. Barron, you have any more?
I'm sorry, I'm here at Tessa Copeland and Mr. Jones is signing just flying up right now.
Copeland?
Yeah.
Okay. Mr. Brennan?
Yes.
I don't have my bail today, I'll say. Do you have Mr. Larson's contact
Mr. Councilman.
I want to say, he's here,
Yes.
yeah, I believe he needs to talk to the client provider, and see if he wants to resolve this case, I think he's been hold on it. I can see this.
Okay. And then, Mr. Ford.
He's not up there right now, he might be able to tell you that.
Okay, thank you. Let's see the, counsel for the civil case, are all counsel present already?
Yes, Your Honor.
Okay, can I talk to you, Sidebar, for a moment? Right.
And my experts are coming in Monday, Wednesday, next week. So we understand that we're, your hands are tied. Yeah, they get crazy and they're so expensive.
Everybody, people are still 49 years. Okay, I just want to make sure we're all on the same page. All right, Ms. Hunter, hi, ready? Not yet. Mr. Ricker. Charlie. Charlie. How are you?
How are you?
Good.
Sound like that was to withdraw.
That's also not the case. Okay.
I just want to say that.
Oh, good, good. So, child advocacy.
Yeah.
Let me go get my paper. Well, yeah. Yeah. All right.
See it.
That's cool, thank you.
Yes. Thank you. There's the way to.
Oh, thank you.
No worries. Sure. See other questions here? Did you really want to that say?
Mine, right?
Yes, I'm good.
All right. This is the matter of State of Ohio versus Tessa Copeland, case number B 2305594. Ms. Copeland is present in the courtroom with her attorney, Mr. Robert Jones, and Ms. Jennifer Deering on behalf of the State of Ohio. This matter is on today for jury trial, but I have been handed plea documents and been advised that this is how the parties wish to resolve this matter today. Mr. Jones, is this accurate?
Correct.
All right, Ms. Deering, is your understanding?
Yes, sir.
Ms. Copeland, is that your understanding? Is that what you want to do today?
Yes.
All right, Mr. Jones, can you make sure that the microphone is on for me? It's not. Thank you. Are you the Tessa Copeland named in this indictment?
Yes.
How old are you?
28.
28? How far did you go to school?
I got my high school diploma.
So you're able to read and write the English language well?
Yes, ma'am.
Are you a U.S. citizen?
Yes.
Have you ever served in the military?
No.
Ms. Copeland, I have in my hand a single-page document. It's entitled Waiver of Trial by Jury. At the bottom, there are signatures. I recognize your attorney's signature here, but right above, ma'am, is this your signature where it says defendant, and if you need to step up?
Yes, ma'am.
All right. This is an acknowledgement by you that you understand that you have a constitutional right to have a trial, which is set for today. But when you sign this form, you're indicating to the court, I understand that, but I don't want a trial. I'm waiving or giving up my right to have a trial. Is that your understanding of what you were doing when you signed this form?
Yes.
Did you sign this form after consulting with your attorney about your constitutional right to have a trial? Do you have any questions about this form?
No.
Do you have any questions about your constitutional right to have a trial?
No.
I also have in my hand a 3-page document. And it's entitled Entering Withdrawn Plea of Not Guilty and Entering the Plea of Guilty. On the 3rd page of this document, there are signatures. I recognize Ms. Deering's signature here, prosecutor, your attorney, Mr. Jones' signature here, but up here where it says signature of defendant, is that your signature?
Yes.
All right. Madam Prosecutor, would you please put on the record the party's expectation regarding this plea?
Your Honor, the charges are being amended to aggravated vehicular homicide for count 1 in violation of 2903.06 of the Ohio Revised Code under the A2A section, which is a felony of the 3rd degree. The second count is being amended to vehicular assault in violation of 2903.08 of the Ohio Revised Code in violation of subsection A2A.
A2A or
P, I apologize. Indicating that she was driving recklessly. With pursuant to the plea agreement, the defense is going to waive any defects, any new issuance of a new indictment, rearrangement, or any other defects. Is that correct? Okay. And also, Judge, there is no agreement with regard to sentencing. The state of Ohio would have an opportunity to provide you with sentencing memorandum. I know the defense thinks it would be helpful for you to have a PSI done. And also, I believe that it's part of the agreement that we're indicating that these were committed with separate animuses, not saying that we would issue consecutive sentences. We're not defining that that's what you want to do. We're just making that part of the plea agreement so that they're not argue that what they feel is appropriate and not do what we feel is appropriate.
All right. You indicated that on count 2, it's charged now as aggravated vehicular assault, and you said vehicular assault. Is it
Right.
aggravated or not?
We're changing it to vehicular assault, Judge. The difference is the issue that we would have had at trial is there were some oxycodone and oxymorphone in her system. It was going to be battle of the expert as to whether or not that was the proximate cause of the accident. Because we wanted to stay away from that, I think everybody is in agreement that there was an accident, there was some reckless driving, so that's why we amended it the way we did.
All right, so it's amended count 2 from aggravated vehicular assault to vehicular assault, right? All right, so Mr. Jones, can you come and fix the base of the Ms. Copeland, do you understand what the attorneys are saying?
Yes,
Thank you. All right. Are you under the influence of any medications, alcohol, or drugs today?
No.
Do you now or have you ever had to manage any type of mental health difficulties? Are you presently under any type of probation or community control supervision in this state or any other state? Has anyone threatened, forced, or coerced you in any manner into entering into this plea of guilty today? Has anyone promised you anything at all if you enter into this guilty plea today? Are you making this plea of your own good will?
Yes.
Now, the state has just outlined the expectation of the plea, that it's expected that you're going to enter a guilty plea to both counts. Count 1, aggravated vehicular homicide, reduced from a felony of the first degree down to a felony of the third degree. And count 2, aggravated vehicular assault, being amended and reduced from aggravated vehicular assault, a felony of the second degree, to vehicular assault, a felony of the third degree. Do you understand? Is that what you're talking to your lawyer about?
Yes.
Did you have an opportunity to review this 3-page plea form with your lawyer before today's hearing?
Yes.
Do you understand what it says?
Yes.
Do you have any questions about it? Did your attorney answer all of your questions about it?
Yes.
Ms. Copeland, do you believe you've had enough time to sufficiently consult with your attorney about your entire case before this hearing today?
Yes.
And has your lawyer answered all of your questions to your satisfaction?
Yes.
Have you had an opportunity to review or discuss the evidence, the discovery that the state has against you with your attorney before this hearing today?
Yes.
Mr. Prosecutor, Ms. Prosecutor, I'm sorry, would you please put on the record whether or not the state has provided all discovery evidence, including any Brady material evidence, if any, to your knowledge, to the defense? Mr. Jones, you acknowledge receipt of same?
Yes.
Ms. Copeland, are you satisfied with your lawyer?
Yes.
Now, do you understand these 2 charges against you? Count 1, aggravated vehicular homicide, a felony of the third degree, and count 2, vehicular assault, felony of the third degree?
Yes.
Do you understand that if you plead guilty to these offenses, you are making a complete admission that you committed the allegations contained in both counts of the indictment as induced?
Yes.
Do you understand that if you plead guilty, the court may enter a judgment of guilt against you and proceed to sentence you immediately?
Yes.
Now, I do understand that because of the type of case that I expect the defense is going to ask for a pre-sentence investigation report and there's an impact statement on behalf of the city, and I'm going to do that. But I need you to know that I could just sentence you today. Do you understand?
Yes.
Now, both of these offenses being reduced to felonies of the third degree, do you understand that you're facing up to 5 years in prison on each count and up to a $10,000 fine, maximum fine on each count?
Yes.
Do you understand that if I sentence you to prison, upon your release from prison, you shall be on post-release control for up to 3 years, but not less than 1 year. Do you understand that? So between 1 and 3 years.
Yes.
Are you on post-release control right now?
No.
If you violate the conditions of post-release control, so if I send you to prison and you get out on post-release control and you violate the conditions of post-release control, you could be returned to the institution for a total of up to 1/2 of your original sentence. Do you understand that? Now, do you understand that, you said you're not on post-release control? All right. Well, do you understand that if you are on post-release control and you are convicted of a new felony offense, the sentencing court could add an additional consecutive 1-year prison term or whatever time remains in your post-release control time or whichever is greater. Do you understand? Yes. Do you have any questions? No. Since these are felonies, being reduced to felonies of the 3rd degree, community control or probation is a possibility. Do you understand that I could place you on probation for up to 5 years instead of sending you to prison? Yes. Do you understand that if you are placed on a community control sentence, you would have to abide by all probationary conditions as established by this court? Yes. And if I place you on community control or probation and you violate the conditions of community control, then you would be brought back before me for a more restrictive sanction, which could include a whole host of penalties. But the most severe penalty could be the imposition of prison time, up to the 5 years on each count, to run consecutive to one another. Do you understand? Yes. Now, when I say consecutive, do you understand what that means? One after another? Mm-hmm. Yes. All right. Also, if I impose court costs and you fail to pay the court costs, I could just order you to do community service instead of paying court costs. Do you understand that? Do you have any questions so far? No. When you plead guilty, you give up some very important constitutional rights that I need to make sure that you understand. Do you understand that you have a constitutional right to have a trial, either to the court or to a jury of 12 persons? Yes. Do you understand that you have a constitutional right to confront witnesses here in open court and have them cross-examined by your lawyer? Yes. Do you understand that you have a constitutional right to confront witnesses and have witnesses subpoenaed to come here and testify on your behalf? Yes. Do you understand that you have a constitutional right at trial to require the state of Ohio to prove your guilt beyond a reasonable doubt? And finally, do you understand that at a trial, you cannot be forced to testify against yourself? Do you understand each of these rights that I explained? Yes. Do you have any questions about your constitutional rights? Do you have any questions about anything we discussed today? All right.
May I have 1 moment to talk to the defense counsel?
Yes.
I apologize, Your Honor.
All right, are you all right?
We're good, yes.
Can we proceed?
Yes, ma'am.
All right, thank you. Ms. Copeland, do you understand that if you plead guilty, you are waiving or giving up all of these important constitutional rights that I just outlined for you? Yes. All right. Knowing everything the court has discussed with you, do you still wish to enter a guilty plea to counts 1 and 2, aggravated vehicular homicide and vehicular assault, both felonies of the 3rd degree? Yes. All right. Counsel, is there anything further before I accept the pleas? All right, may I understand the facts?
Yes, Your Honor. This offense took place on or about July 30th in the year 2023 in Hamilton County, Ohio, at approximately 1:57 a.m. on Harrison Avenue. The defendant was operating a motor vehicle She did operate it recklessly, which was approximate cause of her vehicle crossing the line and colliding with a Chrysler 300 that was driven by Ashley Bailey. Ashley Bailey did die as a result of this collision. There was a passenger in the vehicle named Marco Hogan. He did suffer serious injuries as a result of this collision.
Both adults?
They were. And would like to just put on the record that Miss Bailey was out that night picking up Mr. Markle when he was at a celebration. She was a designated sober driver that night, which makes us sad. But I just like the defense to put, once again, waive the record and defects and stipulate that the facts of the offense do constitute the charges in which she's pled to.
Do you waive?
Yes, sir.
All right. So, anything on facts?
No.
All right. All right. Ms. Copeland, did you hear what the prosecutor said you did?
Yes.
Is it true?
Yes.
So, you were driving a car on the west side, Harrison Avenue, and you, was anybody in the car with you?
My kids.
Your kids? How many kids?
3. I have 3 of us.
3 kids. What were you doing out at 1 something in the morning with your kids in the car?
I went to go get them food.
Get food?
Yes, I went to drop them White Castles.
At 1 in the morning? Okay. And so the victim is Ashley? Ms. Bailey was actually doing a good deed for someone else by picking him up and being a designated driver.
She was, yes,
And she was killed.
yes.
And how old was she? And the person in her car, Mr. Markle, how old was he? Was it, and how was he injured?
I do know he had to go to the hospital. I apologize, Your Honor.
That they were both transported?
Yes, they were. And I was gonna make that more elaborate during my, that's what I was hoping to have a sense.
Yes, I understand. Well, I understand. I'm just trying to understand a little bit of. So there, the 2 people in the other car, the Chrysler 300, were killed or badly injured.
Yes.
And what about Ms. Copeland?
She was also injured, Judge. She went to UC. She had tear flag, and that's the way she was out of this accident. Their children were
Her children were harmed too?
slightly. There was no major injuries with the children, Judge. There's some scratches, but anyway, relatively.
They were taken to Children's Hospital and examined there and then eventually released.
Okay. All right. What is your plea to count 1, aggravated vehicular homicide, felony of the 3rd degree? What is your plea? What is your plea to count 2, reduced to vehicular assault, felony of the 3rd degree? Let the record reflect that Tessa Copeland was in court with her attorney, Mr. Robert Jones, and that Ms. Copeland was informed of all of her constitutional rights and has made a knowing, intelligent, and voluntary waiver of those rights. The court finds that Ms. Copeland understands the nature of the charges, the effect of the pleas, as well as the maximum penalties which can be imposed. Finding them to be voluntary, the court accepts the guilty pleas and finds Tessa Copeland guilty as to count 1, aggravated vehicular homicide, reduced to a felony of 3rd degree in violation of Revised Code 2903.06, subsection A2A. And finding her plea to be voluntary as to count 2, accepts the guilty plea and finds Ms. Tessa Copeland guilty as to count 2, vehicular assault, a felony of the 3rd degree in violation of Revised Code 2903.08, subsection A2B. Is there any reason why sentence should not be entered today, counsel?
Judge, we're going to be asking for a pre-sentence investigation report. We also have the opportunity to furnish the court with a sentencing memorandum to help the court come to a decision in this case. So we will be asking for a sentencing day, roughly 30 to 45 days out of information to keep the report. And we can say also.
Okay.
I know that, the family member of the decedent, Ms. Bailey, is here, but by way of Marcy's law, Mr. Marshall is not here, so I think that because of Marcy's law, we need to give him an opportunity to state his position. The victim impact statement.
Correct. All right, so, Ms. Copeland, I am going to order a pre-sentence investigation report and a victim impact statement. And so after court, you will need to, report to probation so they can interview you. They will provide a written report to me of, a lot of information about you other than what you stand convicted of. And I'll get impact statements from the victims and their families. And we will continue this matter for sentencing on September 23rd at 9 a.m. Is that convenient time for you, Mr. Jones and Ms. Geary? September 23rd at 9. And we'll do that, and then you'll be back here at the.
We're also going to do the 24th.
No, we can't Tuesdays, I don't do Tuesdays, that's my administrative day.
25th.
Well, let's see. Is Monday your, Monday?
No, I'm not going to try to say that. I can make it work if that's any day.
Yeah, let's see. I can do it the 25th at 9. 25th at 9 a.m. Ms. Geary, we do the 25th at 9.
That's fine, I just judged, the record, Mr. Markel did just walk in the courtroom, but I'm still asking for the case to be set over before sentencing.
All right, September 25th at 9 a.m. Now, what we can do, and she'll stay on the same bond at this point, but I know you want to get, we're gonna get victim impact statements in writing, and, you want to both provide some type of memo to the court on what I should do as far as sentencing. But if people are here that want to speak today, I won't let them speak today and on the 25th of September, but in order to, not waste anyone's time, if they want to speak today, I will let them speak today.
Thank you. Your Honor, do you have one family member here? You do have one family member that would like to speak, the others I think would like to reserve their opportunity.
All right, thank you very much. All right, step over this way. All right. Ma'am, will you please state your name?
Daniqua Bailey. Daniqua Bailey.
Daniqua Bailey.
Yes.
All right, thank you. And Ms. Bailey, how are you related to, Ms. Bailey?
I'm actually second cousin of my person.
All right, thank you very much. What would you like to say?
This been tragic to our whole family, and I want that we got a sorry to our family, or even to actual kids, and it's just like,
Excuse me.
Okay, so talk louder, because she's having trouble.
I'm sorry. Since the accident last year,
Hold on one second. Are you good? All right, go ahead.
since the accident last year, Seth had like reached out and said sorry to the family, or like anything to her kids, or just, she's sorry about the situation. It's bad, my cousin lost her life, now she was going to pick from home. Like her kids, do not got him home no more. Like at all. And nothing we can do to try to be there for the kids. It's just like,
How old are the kids?
her daughter is 16. Right? How old is she? 8,
16, 11, 8,
and 6. Her son started kindergarten last year, and she wasn't the person that took her there. She passed right before. It's just sad because we here, and it's like she lost her life, and she has her, she's really to see her kids. My cousin kids have to see her at the gravesite. That's sad. That's sad.
Thank you, Ms. Bailey, I appreciate it.
Thank you.
All right,
Today.
so, Mr. Jones will make sure that Ms. Copeland goes to probation, and we'll see everyone back here September 25th at 9. All right, thank you very much. This is, Ms. Hunter's report. Mr. Larson, you ready?
Yes, we're just on the,
This is the matter of State of Ohio versus Brian Hodge, case number B2402593. Mr. Hodge is present in the courtroom with his attorney, Mr. Eric Larson, and Mr. Brandon Brown from the state of Ohio. This matter is on today for pre-conviction habeas return. And we already have parameters set around this case. Mr. Larson, we have a final pretrial conference, August 28th. And a jury trial set September 9th. Now, the reason this is on today is because a warrant was issued for Mr. Hodge's arrest because he allegedly is violating the terms of his electronic monitoring. So the pretrial services officer indicated that on August 8th, the court was notified that Mr. Hodge was violating his curfew, and the court advised the probation officer that if the defendant continued to violate his curfew, a revocation would be issued. On August 9th, 10th, and 12th, the defendant left his home unapproved, thus violating his curfew. So that's why we're here. That's why a habeas is issued. But we have a trial date set September 9th. Mr. Larson, have you spoken to your client about this violation?
I have, and I would like to be heard as to this particular violation.
Okay, go ahead.
I'm hoping to get him out in the trial. I had spoken initially with, or Ms. Howard reached out to me to advise me that there were issues. I spoke to my client and passed on to him what was passed on to me, which was you do have time out for treatment and you do have time out to look for a job. At the very least, the most recent, for lack of a better word, violation that resulted in ultimately in Officer Miyagawa arresting him and bringing him in, my client advises me that he had called the officer, left a message, went to a McDonald's near his home, scanned, because it has to be done on his phone with a QR code at the McDonald's to apply for work. And then, was ultimately, there was a printed application or something like that, and then returned home.
What day was that?
Monday, not this past Monday? A week from today?
So that was the 12th.
Yes.
That explains the 12th. What about the other days?
Only, I want you to clarify that. On the other days, Your Honor, there's been some challenges at home. His girlfriend, who has been in charge functionally of the upkeep of the home in terms of shopping and being outside,
was admitted to the hospital for a while. It was a situation where he was stuck without any groceries, convenience store and back. An unfortunate situation we were in it, but that's the situation there. All of the violations you'll note were brief and not situations where he's leaving for a tremendous amount of time.
Well,
15, 20 minutes of.
I understand, but these are all clear violations. So what I see, because the officer came to the court and said, we really don't want to violate him, but he just won't listen. He just goes out when he wants to, and he goes to the store, he does what he wants to do, as if he doesn't have electronic monitoring on. So I said, okay, well, let him know that if he continues, for whatever reason, then he's gonna be violated. And that's what happened. So this was your choice. I can see that if this happened and you weren't aware that it was going to happen, I don't know if you thought that the court was kidding, but we let you know in advance. And that way it would be your choice. So you're in the Justice Center because of your choice. I gave you a chance by even letting you know that you were going to be violated. And you, three more days, you just kept going.
Your Honor, I went to the methadone clinic on Friday, and I went to the hospital, my girlfriend had a miscarriage.
These are not those times.
I'm sorry.
These are not those times. So, Mr. Larson, you were saying?
I don't have much to add beyond that, Your Honor. This is a B&E F5. His situation is tricky because of these issues in his personal life. I know that when he spoke with me, he understood treatment and job, and that's functionally what he was trying to do with something.
All right, State.
Judge, I'll refer, I really don't have much information about the nature of the violations beyond what was provided today.
So, we have final pretrial conference on August 28th, trial date September 9th. I'm ready to resolve it by way of trial or plea, either way. How long has Mr. Hodge been in the Justice Center?
Your Honor, in the facts of this matter, there were two issues that took place. One was a misdemeanor, and then there's this felony. For that misdemeanor, he has done the full amount of time on that. Well, full amount of time, he was given 30 days, and he did all of that. Originally, with this OR issue, all of that time didn't count, but he was in for that. He was arrested on this specific incident, I believe Monday last week. Yeah.
So he's been 7 days on this violation.
Yes. We wanted to get in on Thursday, for better or for worse, I was available on Thursday.
So all of these this need to keep going out to the store and coming back for 10 minutes and then going back, all of that, you can't do that in the Justice Center. So why can't you just stay good?
I was trying to get out there because I was trying to get a job, my girlfriend had a miscarriage.
Well, see, this is the thing. You had hours to go get a job. You had hours out. You had hours the probation officer gave you hours. If you would just let the probation office know, I'm going here tomorrow during my out hours to look for a job, that would be acceptable. But that's not what you're doing, Mr. Hodge.
They never gave me hours to be out to look. They never told me hours. They said they never had verification. That's what he told me. He said, I've never had verification for you to go out for a job or work. That's exactly what he told me when they arrested me.
So, without verification, they don't know that you're going to a job interview or look for a job.
I called him and I left a message on his phone. I
I said, Justin, I'm going to McDonald's, trying to get a job. They said I can go to work.
But you can't call and you can't call and then go out and 5 minutes later.
Yes, ma'am.
That's what you're doing. That's why you get yourself in trouble.
I'm sorry.
But if you're saying like on Saturday or Sunday, hey, you know what? I think on Monday and Tuesday, I'm gonna look for a job. I'm gonna call my probation officer. And say, hey, I'm gonna look for a job on Monday morning. They'll give you those hours. They'll say, where are you going? Because you can't just roam the street to look for a job anymore. That's not how this works anymore. Did you know that?
No, it's just going on specific, right?
To McDonald's, close to your house?
Yeah, right.
Which one is that?
On Montgomery Road, right by Kroger's.
Yes. In Oakland.
15 minutes of walk there.
Mm-hmm. And so did you apply?
I was applying when he arrested me because I had to put it on the app and come back.
But you'd already been there.
You had to scan, yes, you had to scan the barcode, and then when I got back to the house, I was fill it out. And when he came to the door, he said, I'm arresting you, I'm filling out an application, I'm looking for a job.
So they gave you a written application?
No.
It's a QR
It's a
code.
QR code.
Oh, I see. I see.
Because I worked at McDonald's before the 9/11, I just thought I'd do it there because I had experience in the real.
Mm-hmm. So if you're in the Justice Center, you can't look for a job?
No agreement.
So I don't know if you're ready for me to let you back out, because all you're gonna do is keep fighting.
No.
Look, Mr. Hyde, I don't want you to be sitting in the Justice Center. I don't want that. But you're also gonna follow the rules of the court.
Yes, ma'am.
And you've been a thorn in probation's side because you won't follow the rules. You just keep going out when you're not supposed to. So, I think what we'll do is we're gonna, continue this to the 28th. And I will decide whether or not by then I'll give them another chance. Okay? But not today. So, continue as already scheduled?
Thank you.
All right, we'll see you then. Mr. Larson, is his girlfriend back home?
Hang on, I'll find out. She is there.
She's there now, okay, well, I'll let you know.
Thank you, Judge.
All right. Thank you. Good morning. Well. Morning.
Yes, we start on Tuesday.
Counsel for the trial, let's, just 1 second, just listen. I'll call you up and just step to the side. Just a second. All right, so this is the matter of Catherine Wollenberg et al. Versus Us Obstetrics for and Gynecology Group Inc. et al. Case A22-04698. I have both counsel of record present, Ms. Lindsay Lawrence and Caldwell.
No, Michael Lyon, that's all right.
Michael Lyon. That's right, I'm sorry, Mr. Lyon.
Much better looking.
All right, so, it looks like, as we're waiting in line for juries and other rooms are ahead of us, and, don't know how this is gonna work out yet, but I know that I've talked to you, previously, and your preference that if we cannot start in a given amount of time today, then you prefer to continue?
Yes, sure.
It's a joint request then? Yes. All right, so it looks like we have January 21st. And right now, I can give you the entire 2 weeks. So we will just, I think there's only a couple things on the calendar, but I can move everything, to give you the entire 2 weeks. So that we will be able to start on the 21st of January. And that's the day after Martin Luther King Day. So that's why we're starting on Tuesday, or I know, start on Tuesday. But, we will start on Tuesday, January 21st, 10 a.m. I will give you the whole week. I have nothing, I have one thing, 2 things conflicting, but I will move those so that you will have the benefit of all day, each of those days for 2 weeks. So the 21st and 31st, so I'm hoping we can get it done. Okay? All right. So thank you very much for your patience. And I know that you've given me a set of exhibits. Do you want to take those back with you now, or do you want to?
I don't think, Judge, if it's okay, it's probably best to leave them here.
Okay.
That's our report.
We'll just keep them.
I do have a request, Judge, if we may. We have at least one motion that has to do with sex messaging, and then we have a couple other issues as to relative to revocation.
You want them to resolve the question?
Is there any way we can make it now, we know we're not, we can meet sometime this week and discuss those?
For the motions, well, let's see. I don't know if this is, but maybe.
Your Honor, if I may add something.
Sure.
Mr. Lyon has filed several replies to our original motions, I think, and per your rules of the court, parties are not allowed to file replies.
Yes, so they won't be considered with this using according to the rules, but,
That's my point, Judge, we're far enough from the trial, there's some of the evidentiary issues I would like to discuss.
I'd like to be able to rule on it as well.
Right.
So that, we can at least have the benefit of one. Is it necessary for your, to have oral arguments on the motions and motions?
I think so, Judge.
Okay.
Your Honor, my understanding was that the pre-trial, you said you were gonna take them into advance and then rule on them.
As we were going, I'm gonna take a look at them again to see, because some of them are, aligned with others.
Right.
And they can be grouped. And so, you know, I need to look at them again, because those that need to be ruled on, that I can rule on in advance, I will. And those that I have to hear some evidence on, I have to wait.
Judge, just give me an example of 2 issues, one of which is evidence of revocation, state court revocation, and secondly, prior lawsuits. Now, we think it's axiomatic that they are not admissible in the first district. We have the case in the first district. We can wait a trial for that, but I thought before we even start with our, we ought to get some clarity on whether the court sits on those issues so that we don't get ourselves on a path.
Yeah. I think that what I'd like to do is, some of this is very clear, like if that's an example, you know, that wouldn't that be very clear to either the law is this or is that?
Well, Your Honor, in response, even though Mr. Lyon had filed it, you know, we're giving me a copy of it just this morning, so we've not had time to file a response. The issue with the state board revocation goes to 4 sexual harassment claims that were brought against the physician in Kentucky, and then when he went to renew his medical license in Ohio, he lied on the application. So then Ohio then suspended his license for 30 days. So the fact that he lied and said that he answered no to any previous suits, that's why they suspended his license for 30 days, which goes directly to his truth and character, which should be admissible for those purposes.
All right. So I think that, we may need some, argument, but I do want to give you an opportunity to look at it. So why don't we do this? Why don't we set it for, Monday afternoon,
What time?
26th,
Okay,
1:30.
thank you.
That gives me time to see what I want to hear argument on, okay? And I'll be able to, streamline the time we're gonna spend together in hearing arguments, okay?
Thank you.
So we'll do it Monday, the 26th at 1:30, okay? Thank you.
Sorry about that. Right.
Ms. May, what we'll do is usually we just on every single day. So that way, yeah, you can say. All right, Ms. Chase, this is the matter of State of Ohio versus Kenneth Davis, case number B2304715. Mr. Davis is present in the courtroom with his attorney, Ms. Darcy Winston, and Mr. Tom Boyd for the State of Ohio. This matter is on for a jury trial today, but it's my understanding that the parties have reached an agreement. I've been handed plea documents, and Ms. Winston, is this how your client wishes to proceed?
Yes, Your Honor.
All right, Mr. Davis, is that true? All right. Are you the Kenneth Davis named in this indictment? Mr. Davis, how old are you? And how far did you go in school? Did you ever obtain your GED or high school diploma? All right. Are you able to read and write the English language well? Are you a U.S. citizen? Have you ever served in the military? Mr. Davis, I have in my hand a single-page document, and it's entitled Waiver of Trial by Jury. At the bottom, there are signatures. I recognize your attorney's signature, Ms. Winston. Is this your signature right above where it says defendant? All right. Now, this is an acknowledgement by you that you understand that you have a constitutional right to have a trial, and that trial is set actually for today. But when you sign this form, you're indicating to the court, I understand that, but I don't want to have a trial. I'm waiving my right, I'm giving up my right to have a trial. Is that your understanding of what you're doing when you sign this form? Did you sign this form after you consulted with Ms. Winston about your constitutional right to have a trial? Do you have any questions about this form? Do you have any questions about your constitutional right to have a trial? I also have in my hand a 3-page document, and it's entitled Entering, Withdrawing Plea of Not Guilty and Entering a Plea of Guilty. And on the 3rd page of the document, there are signatures. I recognize the prosecutor, Mr. Boykin's signature and his bar number. I recognize Ms. Winston's signature here, but right here, sir, is this your signature? If you can't see it, you can come up to the podium. Can you see this? Okay, is this your signature? All right, thank you. Mr. Boykin, would you please put on the record the price expectation regarding the plea?
There's one expectations of guilty plea.
Guilty plea is charged?
Yes, sir.
All right, thank you very much. Ms. Winston, is that accurate?
Yes, Your Honor.
And Mr. Davis, is that your understanding of what you're doing today? All right. Mr. Davis, are you under the influence of any medications, any alcohol or drugs today? Do you now or have you ever had to manage any type of mental health difficulties? Are you presently under any type of probation or community control supervision in this state or any other state? Has anyone threatened, forced, or coerced you in any manner into entering into this plea of guilty today? Has anyone promised you anything at all if you enter into this plea of guilty? Are you making this plea of your own free will? Now, the state has indicated that you're going to plead guilty as charged to the single count indictment of non-supportive dependence, a felony of the 5th degree. Is that what you talked with Ms. Winston about before this hearing today? Did you have an opportunity to review this 3-page plea form with your lawyer before this hearing? Do you have any questions about it? Did Ms. Winston answer all of your questions about it? Do you understand what it says? All right. Mr. Davis, do you believe you had enough time to sufficiently consult with your lawyer about your entire case before this hearing today? And has your lawyer answered all of your questions to your satisfaction? Have you had an opportunity to review and or discuss the evidence that the state has against you with Ms. Winston before today's hearing? All right. Mr. Prosecutor, would you please put on the record whether or not the state has provided all discovery evidence, including any Brady material evidence taken to your knowledge?
State has.
All right. Ms. Winston, you acknowledge you see the same?
Yes, Your Honor.
All right. Mr. Davis, are you satisfied with your lawyer? Now, do you understand this charge against you in count 1? Non-support of dependence, a felony of the 5th degree.
Yes.
You understand that if you plead guilty to this offense, you are making a complete admission that you committed the allegations contained in this indictment. And do you understand that if you plead guilty, the court may enter a judgment of guilt against you and proceed to sentence you immediately? This being a felony of the 5th degree, non-supportive dependence, do you understand that you're facing up to 12 months in prison and up to a maximum fine of $2,500? Do you understand that if I sentence you to prison, upon your release from prison, you could be on post-release control for up to 5 years? And, no, I didn't even say that. It's not 5 years. It's up to 2 years. Do you understand that? Okay. And if you violate the conditions of post-release control, you could be returned to the institution for a total of up to 1/2 of your original sentence. Do you understand? Are you on post-release control right now? All right. You understand that if you are on post-release control and you're convicted of a new felony offense, in addition to being punished for the new felony offense, the sentencing court could add an additional consecutive 1-year prison term or whatever time remains in your post-release control time, or whichever is greater. Do you understand? All right. Do you have any questions? Since this is a felony of the 5th degree, community control or probation is a possibility. Do you understand that I can place you on community control or probation for up to 5 years instead of sending you to prison? Do you understand that if I do place you on community control, that you will have to abide by all probationary conditions as established by this court? And if I place you on community control and you violate the conditions of community control, then you would be brought back before me for a more restrictive sanction, which could include a whole host of penalties, but the most severe penalty could be the imposition of prison time up to the 12 months I previously discussed with you. You understand? Also, if I impose court costs and you fail to pay those court costs, I could order you to do community service instead of paying court costs. You understand that? You have any questions? All right. Mr. Davis, when you plead guilty, you give up some very important constitutional rights, and I need to make sure that you understand. Do you understand that you have a constitutional right to have a trial, either to the court or to a jury of 12 persons? Do you understand that you have a constitutional right to confront witnesses here in open court and have them cross-examined by your lawyer? Do you understand that you have a constitutional right to have witnesses subpoenaed to come to court and testify for you? Do you understand that at a trial, it's the obligation of the state of Ohio to prove your guilt beyond a reasonable doubt? And finally, do you understand that at a trial, you cannot be forced to testify against yourself? Do you understand each of these rights as I've explained it? Do you have any questions about your constitutional rights? Do you have any questions about anything we discussed today? Do you understand that if you plead guilty, you are waiving or giving up all of these important constitutional rights in this case? Mr. Davis, knowing everything the court has discussed with you today, do you still wish to enter a guilty plea as charged to count 1, non-supportive dependence, a felony of 5th degree? All right. Counsel, is there anything further before I accept the plea?
No, Your Honor.
May I hear your statement of facts?
Judge Kenneth Davis was the first day of October 2021. The first day of October 2023 at Henry County, State of Ohio, did recklessly fail to provide support as established by a court order to Terry Smith, a person by court of decree. Defendant was legally obligated to support, and the amount for support was due and owing prior to the date defendant's duty to pay principal was terminated. It remains unpaid, and defendant failed to provide support for a period of 26 weeks out of 104 consecutive weeks in violation of 1921 B1B of the Ohio Revised Code. Until the court, there is currently $42,125.
Coverage. All right. Anything on the facts, counsel?
No, Your Honor.
All right. Mr. Davis, do you hear what the prosecutor said you did? Is it true? You didn't pay your child support and you owe $42,125 in arrears?
I have a job, I was spared.
Well, I'm gonna get to that in just one moment. I just want to ask you, is it true?
Yeah.
All right. What is your plea to count 1, non-supportive dependence, a felony of 5th degree? Let the record reflect that Mr. Kenneth Davis was present for with his attorney, Mr. Darcy Winston, and that Mr. Davis was informed of all of his constitutional rights and has made a knowing, intelligent, and voluntary waiver of those rights. The court finds that Mr. Davis understands the nature of the charge, the effect of the plea, as well as the maximum penalties which can be imposed. Finding it to be voluntary, the court accepts the guilty plea and finds Mr. Kenneth Davis guilty as charged, count 1, non-supportive dependence, a felony of 5th degree, in violation of Revised Code 2919.21, subsection B1B. Counsel, is there any reason why the sentence should not be entered today?
We are prepared to go forward, Your Honor, today. However, it's my understanding, the state is going to request a victim impact statement.
That's great,
Okay. All right. So, Mr. Davis, there is a law, Marcy's law, that we have to give victims an opportunity to weigh in on any substantive matter in the case, and sentencing is a substantive matter. Okay? So what I'm going to do is I'm going to order a victim impact. You waive PSI, Mr. Winston?
Yes, Your Honor.
All right, PSI is waived. But I will order a victim impact statement. And I will continue this matter for sentencing. And I'm just going to continue to the end of the month because we're not getting the PSI, so I have to wait 30 days. So how about the 29th?
Your Honor, I was gonna suggest that because I'm here anyway.
Okay, great. August 29th for sentencing. August 29th for sentencing at 9 a.m. Mr. Davis, please keep in contact with your lawyer, and then I'll see you back here, August 29th at 9 a.m. Okay, thank you.
Thank you very much.
Thank you. Mr. Whitmire and Ms. Hunter. Mr. Ford, are you here?
I did not see the judge, no.
Is Megan Marshall here? Can you call him all in person?
Sure. Megan Marshall here, Megan. There's nobody up there, Judge, talk about.
All right, thank you. So what I'm gonna do is, on the case made, State of Ohio versus Megan Marshall, B 2401194. I'm gonna continue it as already scheduled for the final pretrial conference. Council didn't show up today. I don't know why. So maybe there's nothing to do on that. I don't know. All right, I have Kelly Williams and Malcolm Phelps. I have a plea form for Mr. Kelly Williams, and then Mr. Tippmeyer, what are you doing?
It's gonna be a plea as well, Judge.
Okay, all right, so let's, you need a second. You need a second.
Thank you.
Okay. This is a matter of State of Ohio versus Kelly Williams, case number B 2401274. Mr. Williams is present in the courtroom with his attorney, Mr. Wanda Hunter, and Mr. Brandon Brown from the State of Ohio. This matter is set for a jury trial today, but it's my understanding that the parties have reached an agreement, and I've been handed plea documents. Ms. Hunter, is this how your client wishes to proceed? All right, Mr. Williams, is that true?
Yes, ma'am.
All right. Are you the Kelly Williams named in this indictment?
Yes, ma'am.
Mr. Williams, how old are you?
34.
34?
Yes.
How far did you go to school?
GD.
So you're able to read and write English language well?
Yes, ma'am.
Now, are you a U.S. citizen?
Yes, ma'am.
Have you ever served in the military?
No, ma'am.
Okay. Mr. Williams, I have in my hand a single-page document. It's entitled Waiver of Trial by Jury. At the bottom, there are signatures. I recognize Ms. Hunter's signature here. The red above, is that your signature?
Yes, ma'am.
Can you see it from there?
Yes,
Okay. This is an acknowledgement by you that you understand your constitutional right to have a trial, which is set for today. But when you sign this form, you're indicating to the court, I understand my right, but I don't want to have a trial. I'm waiving my right to a trial. Is that your understanding of what you were doing when you signed this form?
Yes, ma'am.
Did you sign this form after consulting with Ms. Hunter about your right to a trial?
Yes, ma'am.
Any questions about this form?
No.
Any questions about your right to have constitutional right to have a trial? I also have in my hand a 3-page document, and it is entitled Entry Withdrawing Plea of Not Guilty and Entering a Plea of Guilty. On the 3rd page, there are signatures, and I do recognize Mr. Brown's signature here, because I see his signature all the time, and I recognize Ms. Hunter's signature, because I see her signature all the time. But is this your signature here, sir, or is this signature of the defendant?
Yes, ma'am.
All right. Mr. Prosecutor, can you please put on the record the party's expectation regarding this plea?
Judge, expecting the defendant to plead guilty to count 2, possession of fentanyl or related compound as a felony of the 5th degree, as well as count 3, possession of drugs as a felony of the 5th degree. The state will be dismissing count 5.
Okay. So they're as charged. Correct. Is that accurate, Ms. Hunter?
It is, Your Honor.
Is that your understanding too, Mr. Williams?
Yes, ma'am.
Mr. Williams, are you under the influence of any medications, any alcohol or drugs today?
No.
Do you now, have you ever had to manage any type of mental health difficulties?
Yes.
Can you just tell me just a little bit about it, just a summary?
ADHD, went to BJ program, mental health for Hillcrest.
Okay. Have you, in River City?
University.
Okay. Can you tell me, have you ever been diagnosed with anything other than ADHD, and have you had any prescription
No.
prescribed? No? Okay, thank you. Are you presently under any type of probation or community control supervision in this state or any other state?
No.
Has anyone threatened, forced, or coerced you in any manner into entering into the plea of guilty today?
No.
Has anyone promised you anything at all, other than the dismissal of count 1 if you enter into the pleas of guilty to count 2 and 3?
No.
Are you making this plea of your own free will?
Yes.
Now, the state has indicated that of this 3-count indictment, you're expected to plead guilty to counts 2 and 3 as charged in exchange for the dismissal of count 1. Is that what you talked with Ms. Hunter about before this hearing?
Yes, sir.
And did you have an opportunity to review this 3-page plea form with her before this hearing today?
Yes, sir.
Do you understand what it says?
Yes, sir.
Any questions about it?
No.
Did Ms. Hunter answer all of your questions about it?
Yes.
Mr. Williams, do you believe that you had enough time to sufficiently consult with Ms. Hunter about your entire case before this hearing today?
Yes, sir.
And has Ms. Hunter answered all of your questions to your satisfaction?
Yes, sir.
Have you had an opportunity to review and or discuss the evidence that the state has against you with Ms. Hunter before this hearing?
Yes, sir.
All right. Mr. Prosecutor, would you please put on the record whether or not the state is providing all discovery evidence, including any Brady material evidence, if any to your knowledge?
Yes, Judge, we provided all discovery.
Ms. Hunter, you acknowledge and see the same? Yes, sir. Okay. Mr. Williams, are you satisfied with your attorney, Ms. Hunter?
Yes, sir.
Now, do you understand the 2 charges against you, counts 2 and count 3, possession of a fentanyl-related compound, and possession of drugs, felonies to the 5th degree?
Yes, sir.
Do you understand that if you plead guilty to these offenses, you are making a complete admission that you committed the allegations contained in counts 2 and 3 of the indictment?
Yes, sir.
And do you understand that if you plead guilty, the court may enter a judgment of guilt against you and just proceed to sentence you immediately?
Yes, sir.
Now, both of these being felonies of the 5th degree, do you understand that you are facing up to 12 months in prison on each count and up to a maximum fine of $2,500 on each count?
Yes, sir.
Do you understand that if I sentence you to prison upon your release from prison, you could be on post-release control for up to 2 years?
Yes, sir.
And if you violate the conditions of post-release control, you could be returned to the institution for a total of up to 1/2 of your original sentence. Do you understand?
Yes, sir.
Are you on post-release control right now?
No.
Well, do you understand that if you are on post-release control and you commit a new felony offense while on post-release control, in addition to being punished for the new felony offense, the sentencing court could add an additional consecutive 1-year prison term or whatever time remains of your post-release control time, or whichever is greater. Do you understand that?
Yes, sir.
All right. Do you have any questions so far?
No.
Well, since these are felonies of the 5th degree, community control or probation is also a possibility. Do you understand that I can place you on probation for up to 5 years instead of sending you to prison?
Yes, sir.
Do you understand that if you are placed on community control or probationary sentence, you will have to abide by all probationary conditions as established by this court?
Yes, sir.
And if I place you on community control and you violate the conditions of community control, then you would be brought back before me for a more restrictive sanction, which could include a whole host of penalties, but the most severe penalty could be the imposition of prison time up to the 12 months on each count that I previously discussed with you. Do you understand?
Yes, sir.
Also, if I impose court costs and you fail to pay those court costs, I can just order you to do community service instead of paying court costs. Do you understand?
Yes, sir.
All right. Mr. Williams, do you have any questions so far?
No.
When you plead guilty, you give up some very important constitutional rights, and I need to make sure that you understand. Do you understand that you have a constitutional right to have a trial, either to the court or to a jury of 12 persons?
Yes, sir.
Do you understand that you have a constitutional right to confront witnesses here in open court and have them cross-examined by your lawyer?
Yes,
Do you understand you have a constitutional right to have witnesses subpoenaed to come to court and testify for you?
yes, sir.
Do you understand that at a trial, it's the obligation of the state of Ohio to prove your guilt beyond a reasonable doubt?
Yes, sir.
And finally, do you understand that at a trial, you cannot be forced to testify against yourself?
Yes, sir.
Do you understand each of these rights as I explained them?
Yes, sir.
Do you have any questions about your constitutional rights?
No.
Do you have any questions about anything we discussed today?
No.
Knowing everything the court has discussed with you, do you still wish to hear a guilty plea as charged to counts 2 and 3 of the indictment?
Yes, sir.
Counsel, is there anything further required except please?
No, Your Honor, just that, just according to the former, I believe we're stipulating that this was with his statement.
Okay, thank you very much. May I hear a statement of facts?
Yes, Judge. Kelly Williams, on or about March 14, 2024, Hamilton County, State of Ohio, knowingly obtained, possessed, or used a Schedule II controlled substance to wit fentanyl in an amount less than 1 gram. Also, on March 14, 2024, Hamilton County, State of Ohio, knowingly obtained, possessed, or used a Schedule III controlled substance to wit xylazine in an amount that was less than bulk. And the defendant had previously been convicted of drug abuse offense to wit possession of heroin in Hamilton County Court of Common Pleas, case number B20-00491 on October 1st, 2020.
Judge officers stopped the defendant. He had an active warrant, I believe, out of Fairfax. They searched him incident to arrest and found the light-powered substance. I believe that this was a combination of all three. I don't think, unless the cocaine is separate, but I can't remember what it was. The same
All right, thank you very much. Anything on the facts, counsel? All right, so this was one piece of something, but it had both a combination of
Correct.
both.
I think it's
and
tested
all.
for both, yes.
I see. All right. Mr. Williams, did you hear the prosecutor say he did it?
Yes, sir.
Is it true?
Yes, sir.
What is your plea to count 2? Possession of fentanyl with a compound of felony with 50 degree.
Yes.
What is your plea to count 3? Possession of drugs, a felony with 5th degree.
Yes.
Let the record reflect that Mr. Kelly Williams was present in court with his attorney, Ms. Shavonda Hunter, and that Mr. Williams was informed of all his constitutional rights, has made a knowing, intelligent, and voluntary waiver of those rights. The court finds that Mr. Williams understands the nature of the charges, the effect of the pleas, as well as the maximum penalties which can be imposed. Finding it to be voluntary, the court accepts the guilty plea, or finding them to be voluntary, the court accepts the guilty pleas and finds Mr. Kelly Williams guilty as charged in count 2, possession of a fentanyl-related compound, a felony of 5th degree, in violation of Revised Code 2925.11, subsection A, and guilty as to count 3, possession of drugs, a felony of 5th degree, in violation of Revised Code 2925.11, subsection A. Count 1 of the indictment is dismissed at the state's request. Counsel, is there any reason why sentence should not be interstate? All right, are you waiting for the PSI? All right. What would you like to say on behalf of Mr. Williams?
Mr. Williams is in Florida. He is working 2 jobs. He's working at his commercial painting and at a t-shirt pressing company. Mr. Williams, I think he's been clean for about 2 to 3 months now, so that's very good. He's keeping himself busy so he stays out of trouble. He hasn't picked up any new charges that I know of since this happened. He applied for rules of his release so far. We would ask the court to for term of probation.
All right. May I hear from the state?
Judge Oliver, I spoke to the officers about this. They didn't have any prior contacts, I believe, with Mr. Williams. This was a situation where he was a hotspot for drug trafficking. He encountered one attached to the car that he was in, searched him.
Okay. Mr. Williams, you hear what the prosecutor said you did?
Yes, ma'am.
Is it true?
Yes, ma'am.
All right. And, is it your lawyer said true?
Yes, I am working 2 jobs. I'm trying to get less out of time myself, so as far as keeping up with my kids and sports and stuff like that, so they can keep me busy.
I see,
I'm
okay.
progressing for us is more important than that.
And you have 2 jobs right now?
Yes, sir.
All right. Counsel, can I see your sidebar just one moment? Yes. All right, Mr. Williams, so you said you work 2 jobs,
Yes, ma'am.
and, if you were drug tested today, you'd be clean?
I got marijuana license.
Do you have a car?
Excuse me?
You have a car?
I don't.
Okay. Oh, I know, it's something, I get it, just was wondering. Just because he said he had some, mental health difficulties in the past, I thought maybe he was using for that. All right, well, thanks for being honest, I appreciate that. Anything else you want me to know?
That's it, the roots being there for my kids, working on saving money, trying to better myself.
All right. So do you need help with the drug possession?
I mean, I've been thinking about going to job. I used to get some programs to go to with a few friends of mine. But I haven't stopped by there yet. I was willing to go on my own.
Okay.
I can show you progression towards that and they take the outcomes.
Yeah. Okay, well, you might be doing that because, I'm gonna put you on a short-term probation. And, so PSI is waived, I'm gonna put you on a, 1-year community control. Be drug and alcohol tested, okay? And then, you pay court costs, there'll be no fine. If you violate, then you, expose yourself to being sent to prison for up to 12 months, you understand?
Yes, ma'am.
And if you, do well on probation for this short period of time, I would consider releasing you early on probation. So you gotta take care of all your stuff. You understand?
Yes, ma'am.
All right. Anything else, Ms. Hunter? No, you're Mr. Brown?
Yes, no, I'm good, sorry.
Okay, all right. Well, you have a right to appeal your conviction. The sentence, should you choose to do so, you must do so within 30 days. If you're not able to process the appeal, the attorney will be appointed to help you at no cost to you. Do you understand?
Yes, ma'am.
All right. So you'll have to report to probation, Okay, all right, thank you. And then my caboose case. Yes.
It was he was attached to the car, like I don't know if he owned the car, but the defendant was attached to it. No, yeah. No problem.
Just get my bearings here. This is a matter of State of Ohio versus Malcolm Phelps, case number B 2400877. Mr. Phelps is present in the courtroom with his attorney, Mr. Brian Tidmeyer, and Mr. Brandon Brown from the State of Ohio. This matter is on today for a jury trial, but I've been handed plea documents, and it appears the parties have reached an agreement on how to resolve this matter. Mr. Tidmeyer, is that actually accurate?
Yes,
All right. Is that your understanding of what's happening to Mr. Phelps? All right. Are you the Malcolm Phelps named in this indictment? Mr. Phelps, how old are you?
26.
26? All right. How far did you go to school?
10th grade.
Did you ever obtain your GED?
No, ma'am.
All right. Are you able to read and write the English language well? Have you, are you a U.S. citizen?
Yes, ma'am.
Have you ever served in the military? All right. Mr. Phelps, I have in my hand a single-page document. I know you sat and watched the last couple, so you know what I'm going to say. But I have in my hand a single-page document entitled Waiver of Trial by Jury. At the bottom there are signatures. I recognize your attorney, Mr. Tidmeyer's signature here, his bar number. Is this your signature right above his here where it says defendant?
Yes, ma'am.
All right. This is an acknowledgement by you that you understand that you have a constitutional right to have a trial, which you said for today. But when you sign this form, you're saying to the court, I understand all of that, but I don't want to have a trial. I'm waiving my right to have a trial. Is that your understanding of what you were doing when you signed this form?
Yes, ma'am.
Did you sign this form after you consulted with your attorney about your constitutional right to have a trial?
Yes, ma'am.
You have any questions about this one?
No.
Do you have any questions about your constitutional right to have a trial? I also have in my hand, Mr. Phelps, a 3-page document, and it's entitled Entering the Joint Plea of Not Guilty and Entering the Plea of Guilty. On the 3rd page, there are signatures. I recognize your attorney's signature right up here, Mr. Brown's signature right here, and they both put their bar numbers, but right up here, sir, where it says signature defendant, is that your signature?
Yes, ma'am.
All right, thank you. Mr. Prosecutor, may I hear your expectation of the plea?
Yes, Judge. State's expecting the defendant to plead guilty to the amended one-count indictment. State's going to amend the charge from trafficking in cocaine as a felony of the 4th degree to an attempt to traffic in cocaine, making it a felony of the 5th degree.
Okay, thank you. Is that accurate, counsel?
Yes, ma'am.
All right, is that your understanding too, Mr. Phelps?
Yes, ma'am.
Sir, are you under the influence of any medications today, or alcohol or drugs?
No,
Do you now, or have you ever had to manage any type of mental health difficulties?
yes, ma'am. I'm diagnosed with bipolar and depression.
Okay, and,
ADHD, of course, but ADHD, I'm sorry.
okay, thank you. Have you been prescribed medication to help you manage those, diagnoses?
Previously, for lithium. Yes, ma'am.
Are you still, taking the medication?
No, ma'am.
Were you taken off, or did you just stop?
It was kind of both, because I was attending the drug court program before I got over here.
Yes.
I had lost services when
You had, I'm sorry.
I had lost services and when they could send me over here, because I got kicked out of the drug court thing program.
Oh, okay, so do you have a doctor?
No, ma'am, but, I was gonna tell you everything at the end.
Okay, but I just wanna know about your ability to understand what's going on. So you are prescribed, you were prescribed medication,
Yes, ma'am.
but you don't have that now. How long have you not had your medication?
6 days.
About 2 months?
2 or 3.
Okay.
I thought it was long.
Okay. But do you have a plan to try to get back on your medication?
Yes, ma'am.
Okay, all right, now I'll hear that in a minute. So let me just make sure today, are you, do you think that you've had good communications with your lawyer?
Yes, ma'am.
And have you been able to understand fully everything he's advised you?
Yes, ma'am.
All right. If at any time you don't understand something that's going on here today, or don't understand something I'm saying, please stop me. I'm happy to just tell you, or say it a different way, okay? All right. Are you presently under any type of probation or community control supervision in this state or any other state?
No, ma'am.
Has anyone threatened, forced, or coerced you in any manner into entering into this plea of guilty today? Has anyone promised you anything at all if you enter into this plea of guilty today? Are you making this plea up because you want to of your own free will? Now, the state has indicated that it's expected that you're going to enter a guilty plea to the reduced and amended charge from a trafficking in cocaine felony 4th degree down to an attempt felony 5th degree. Is that what you talked with Mr. Tittmeyer about before this hearing today?
Yes, ma'am.
Did you have an opportunity, sir, to review the 3-page plea form with your lawyer before today?
Yes, ma'am.
Or before this hearing this morning?
Yes, ma'am.
All right. Do you understand what it says? Do you have any questions about it?
No.
Did Mr. Tittmeyer answer all of your questions about it?
Yes, ma'am.
Mr. Phelps, do you believe you had enough time to sufficiently consult with your lawyer about your entire case before this hearing today? And has your lawyer answered all of your questions to your satisfaction? Have you had an opportunity to go over to review or discuss the evidence with your lawyer, the evidence that the state has against you? Called discovery.
Yes, ma'am.
Okay. Mr. Prosecutor, would you please put on the record whether or not the state has provided all discovery evidence, including any Brady material evidence, if any, to your knowledge, to the defense?
Yes, Judge, states provided all known discovery, also specifically note, there is a video, be alleged by the situation with the CI. I made that available, counsel, if you did not specifically give that.
I see, okay. Mr. Tittmeyer, is this accurate?
Yes, ma'am.
All right, you, acknowledge what you're saying?
Yes,
All right. Mr. Phelps, are you satisfied with your lawyer?
Yes, ma'am.
Now, do you understand this reduced and amended charge of attempt of felony with 5th degree? You understand that charge?
Yes, ma'am.
Okay. Do you understand that if you plead guilty to this offense, you are making a complete admission that you committed the allegations of attempted trafficking in cocaine? And do you understand that if you plead guilty, the court may enter a judgment of guilt against you and proceed to sentence you immediately? Now, this being reduced to a felony of the 5th degree, do you understand that you're facing up to 12 months in prison and up to a maximum fine of $2,500. You understand that if I sentence you to prison upon your release from prison, you could be on post-release control for up to 2 years. And if you violate the conditions of post-release control, you could be returned to the institution for a total of up to 1/2 of your original sentence. Do you understand that? All right. Mr. Phelps, are you on post-release control right now?
No.
Okay. Do you understand that if you are on post-release control and you committed new felony offense while on post-release control, in addition to being punished for the new felony offense, the sentencing court could add an additional consecutive 1-year prison term or whatever time remains in your post-release control time, or whichever is greater. Do you understand? All right. Do you have any questions so far?
No.
Since this is a felony of the 5th degree, community control or probation is a possibility. Do you understand that I could place you on probation for up to 5 years instead of sending you to prison? Do you understand that if you are placed on a community control or probationary sentence, you will have to abide by all probationary conditions as established by this court? And if I place you on community control and you violate the conditions, then you have to be brought back before me for a more restrictive sanction, which could include a whole host of penalties. But the most severe penalty could be the imposition of prison time up to the 12 months I previously discussed with you. You understand? Do you have any questions so far? Also, Mr. Phelps, if I impose court costs and you fail to pay those court costs, I can just order you to do community service instead of paying court costs. You understand? Okay. When you plead guilty, you give up some very important constitutional rights that I need to make sure that you understand in this case. Do you understand that you have a constitutional right to have a trial, which is set for today, either to the court or to a jury of 12 persons?
Yes, ma'am.
Do you understand that you have a constitutional right to confront witnesses here in open court and have them cross-examined by your lawyer? Do you understand that you have a constitutional right to have witnesses subpoenaed to come to court and testify for you? Do you understand that at a trial, it's the obligation of the state of Ohio to prove your guilt beyond a reasonable doubt? Do you understand that? And finally, do you understand that you cannot be forced to testify against yourself at a trial? You understand?
Yes, ma'am.
Do you understand each of these rights as I explained them?
I do. Yes, ma'am.
Do you have any questions about your constitutional rights? Do you have any questions about anything we discussed today? Do you understand that if you plead guilty, you are waiving or giving up all of these important constitutional rights in this case? Mr. Phelps, we're almost done, but knowing everything the court has said to you, has spoken to you about, do you still wish to enter a guilty plea to the reduced charge of attempted trafficking in cocaine at felony of the 5th degree?
Yes, ma'am.
All right. Counsel, is there anything further for our secretary?
Nothing at this time, Judge.
All right, Mayor, statement of facts.
Malcolm Phelps on or about February 2nd, 2024, in Hamilton County, state of Ohio, knowingly attempted to sell or offered to sell a Schedule II controlled substance, to wit, cocaine, in an amount that was less than 5 grams, and the offense was committed in the vicinity of a school, in the vicinity of a juvenile, or in the vicinity of a substance addiction services provider or recovering addict. Judge, as I mentioned before, this was officers are doing an investigation conducted at an undercover bottle of CI.
I see. All right, thank you. Anything on the facts, counsel?
Nothing at the facts, Judge.
Mr. Phelps, did you hear what the prosecutor said you did?
Yes, I did.
Is it true?
Then, yes,
Okay.
I didn't, receive that form, and I got it, basically the traffic, I didn't get it, the traffic, and
Yes.
That was what we worked out as a resolution that it was amended to an intended
Okay,
trial.
okay, yeah, that's it.
Yeah, so the trafficking is actually a higher offense, and your lawyer negotiated with the state a lower offense. Do you understand that? All right. Is that, did you hear what the prosecutor said you did?
Yes, sir.
And is it true that you attempted to traffic in cocaine?
Yes, sir.
All right. What is your plea to the reduced charge of attempted trafficking in cocaine, a felony of the 5th degree?
Guilty.
Let the record reflect that Mr. Malcolm Phelps was present in court with his attorney, and that Mr. Phelps was informed of all of his constitutional rights and has made a knowing, intelligent, and voluntary waiver of those rights. The court finds that Mr. Phelps understands the nature of the charge, the effect of the plea, as well as the maximum penalties which can be imposed. Finding it to be voluntary, the court accepts the guilty plea and finds Mr. Malcolm Phelps guilty as to count 1, attempted trafficking in cocaine, a felony of the 5th degree, in violation of revised code 2923.02. Is there any reason why sentence should not be issued today, counsel?
No, Judge, we were going to ask if he could be sentenced today.
All right, waiving the PSI?
Yes, ma'am.
All right, who would like to stand on behalf of Mr. Phelps?
Judge, in mitigation, Mr. Phelps is 26 years old. I've been working with him for several months now. Every time I've dealt with him, he's been polite, courteous, and cooperative. I did speak with the arresting officers as well, who advised the same, that given the circumstances and situations, he was cooperative and was polite to the arresting officers, which I think carries a lot of weight. In general, he does have a mental health problem. I spoke with him today. I believe that's impacting his ability to think and understand and reason today. We've spoken at length. In fact, he's been very, very involved in this offense. He's on time for every meeting. He's early to court. He meets me at court every single day. He's usually here at least half hour early. So I think that should also be considered. But one of the things that's even more important is that he's actually created a plan for himself, which I think is unique that a lot of people don't do. He's working at CityLink. He's doing that as a temporary job, hoping to get full-time employment. But in case that doesn't pull through, he's actually receiving job training through CityLink as well. He's been involved with taking care of his son. As far as his mental health is concerned, he was eligible and was receiving services. He was going through therapy appointments and getting medication for that. I know that was something that he was upset about, that he no longer receives those services, but he's got a plan in place, hopefully with either open enrollment or through a job, that he can get those type of services so he can continue to get the care that he needs. But he has been really involved. As far as drug court, he was started out in drug court, given the fact that it's a trafficking charge. They brought him out to the general division. It wasn't something that he had requested. He, in fact, enjoyed it as an opportunity. He told me to get clean and get his life together. And I think he's done a complete 180. And I think that, if anybody could show that they could be successful in community control, I think Mr. Phelps has done that. Additionally, and I know he's not going to get credit for it, in the sense that he's had the jail credit, but he's been on an ankle monitor this entire time. He's been compliant with that. He's had no bond violations. I know he's excited to resolve the case. As I said, he's been great to work with, so I should consider that change.
All right, thank you. Anything to say?
Judge, I also not to speak to the officers. I agree they say Mr. Phelps was cooperative, and I would first sentence.
Okay. Mr. Phelps, anything you'd like to say, sir, before I pass sentence?
Yes, no, this has been a long journey, learn my laws and my rights. I know wrong from right. I was in jail, did everything responsibility, getting my immigrant stuff, good report. Now, the last time I talked to you, I told you I was, the day up there, I had an interview with CityLink. So I've been with CityLink ever since the whole organization loved me.
That's tremendous.
I just went and paid my reinstatement fees for my license right before court. The program that we committed to as far as license, that's for a mechanic. It's a 6-week course. We get paid $100 a week for it.
How much?
$100 a week for the training course.
Oh, the training.
Yeah, I'm on that for September 23rd.
Okay.
That starts September 23rd. After that, I'm gonna go right back to construction. And I already talked to my the guidance person, excuse me, she about to enroll me into a GED class, and I'm going to counseling too. That's all must turn up right now. The ball is rolling with that. Independent living right now. I got my SNAP stuff together. As you see, when I got arrested, I didn't know that I had active restraining order with the mother of my child.
Okay.
That's been dropped. I've been active in my son's life. Everything we do,
Well, you've been busy
It's been
in a positive way, and I am really proud
I submitted my work, I'm sorry, I submitted my work stuff to the MU office as soon as I got it, so everything is good. I've been had to move like 4 or 5 hours dealing with drama,
Yeah,
temptation, and I kept myself together.
that is tremendous. I'm proud of you for that. And so, I am going to, reward you by terminating your EMD. I'm gonna take you off EMD, so they have to court you, just go right over there.
I gotta go back home and get my charger. I left it. I made sure I was on time. I'm run back and run get it.
But you might want to go take it out first and then go get it and bring it back.
Yes, ma'am.
However you want to do it, whatever.
You tell me how you want to do it.
However you want to do it is fine. The court has considered the overriding purposes of felony sentencing pursuant to revised code 2929, which are to protect the public from future crime of this offender and others similarly minded, and to punish this offender using the minimum sanctions that the court determines accomplish these purposes without imposing an unnecessary burden on state and local government resources. I have considered the need for incapacitation, deterrence, rehabilitation, and restitution. I reasonably calculated this sentence to achieve the 2 overriding purposes of felony sentencing, and to be commensurate with and not demeaning to the seriousness of this offender's conduct and its impact on society, and to be consistent with sentences imposed for similar crimes committed by similar offenders. I've also considered the seriousness and recidivism factors set forth in revised code 2929.12. Accordingly, Mr. Phelps, I hereby sentence you to a term of 1 year of community control, 1 year probation. You will pay costs and fines are going to be waived, remitted. I'm going to terminate your EMD. I fully expect you to be successful, and I will tell you as an incentive to keep doing what you're doing and stay on a good track and stay away from negative influences. If probation tells me in several months that you're just doing a really, really great job, I would consider releasing you early. Okay? If you violate though, then I will not hesitate to sentence you to a term of 12 months in prison. You understand that? All right. All right. Anything else, counsel?
That's just, thank you.
Nothing, Judge.
You have a right to appeal your conviction and sentence. Should you choose to do so, you must do so within 30 days. You cannot afford to process the appeal. An attorney will be appointed to help you at no cost to you. Do you understand?
Yes, ma'am.
Keep up the good work. I wish you well. And you'll have to go over to probation and you can turn we'll send the paperwork over to terminate EMU. And then you gotta go to probation, probation, so they gotta do what they do. But I'm gonna send the paperwork over, terminating the EMT over to EMT. We'll send that now, and so whichever you decide to go home, you enter the box, whatever you charge, whatever you do, just, I would check with them first.
You know, it's always bring the charge report and let us off. They not let us off on this one.
Gotcha, okay, so then, yeah, go do that and bring it back, okay? All right, I wish you well. Thank you. Thank you so much for your help. Appreciate you. Okay.
Gotta call Debbie, sir.
Hey, Mr. Brown.